Start citizenship. Article number 2. So, Article 2 Citizenship Part 2. Okay, this Citizenship Amendment, Article 5. Every person domiciled in the Indian territory are citizen of India. So, if he is born in Indian territory, either of his parents was born in Indian territory or ordinarily resident in territory of India for not less than 5 years, they will be the citizen of India according to the Article 5. Article 6 says that person migrated from Pakistan to territory for India are citizen of India. So first he migrated to Pakistan in Article 6. Okay. Then Article B says migrated before 19 July. So there is a deadline of 19 July. Okay, 19 July 1948. An ordinary citizen from migration and migrated on after 19 July and registered as a citizen of India by the government office. So these was in Article 6. And Article 7 says a person is not a citizen of India if he migrated to Pakistan after the first day of March. So after 1st March, if he migrated to the Pakistan, he will never be the citizen of India. And Article 8 says person ordinarily resident in India country outside India are citizen of India. He has been registered as a citizen of India by the diplomatic or consular representation of India. Article 9 says a person is not a citizen of India. Why? If he voluntarily acquired the citizenship of foreign state. Article 10 says every person is a citizen of India under the provision of any law made by Parliament. And Article 11 says Parliament has power to make any provision with respect to acquisition and termination of citizenship and all the matters relating to the citizenship. So these was some basic important article for the citizenship of India. Now acquisition of citizenship of India. Acquisition of citizenship of India of 1955. Citizenship by birth. So every person can acquire citizenship by birth born on after 26 January 1950 but before the 1 July 1987. Born on after the 1st July 1987 but before the commencement of the Citizenship Act 2003. So commencement of Citizenship Act 2003 is important here. Okay. And either of whose parents is in citizen of India at the time of his birth, he will be a citizen of by birth. Okay. So in citizen by birth there will be 1 July 1987 and Citizenship Act 2003 will be important. So citizenship by naturalization. If the person is not an illegal migrant, if the person satisfies the qualification for naturalization under the provision of 3rd schedule and the person has rendered distinguished service in the field of science, philosophy, art and peace. Now born after commencement of Citizenship Act 2003 cannot acquire citizenship by birth. So parents are enemy aliens and parents are annoy to foreign diplomats. So both of his parents are citizen of India if he was before the Citizenship Amendment Act 2003 or whose parents is a citizen of India. So that will be the some article given here. Now citizenship by descent. So born on the after 26 January 1950 before 10 December 1992. If his father is citizen of India, then born on after the December 1992 and either of his parents is a citizen of India time of birth. Citizenship by registration. So if person is married to a citizen of India, resided in India for 7 years, they are minor children of person who are citizen of India. Person is of full age and capacity whose parents are registered for citizen of India, and person either of his parents was either citizen of independent India and resided in India, and person is registered as an overseas citizen of India. Okay, now Citizenship Act 1955. So Citizenship Act 1955, an act to provide for the acquisition and determination of Indian citizenship. So there was article there was 1986, 1992, 2003 and 2005. These were some acts like citizenship by birth, by descent, by naturalization, by registration or by incorporation of the territory. it is the acquisition, and termination like by renunciation, by termination, and by deprivation. Now glossary is what for the citizenship. Minor person is who do not attain yet 18 year. He is a minor. An illegal migrant, foreigner without any valid passport is known as illegal migrant, and foreigner who remains beyond the permitted beyond the period of the time. Overseas citizen of India origin being a citizen of specified countries is known the overseas citizen, and person registered as an overseas citizen of India by the central government under section 7A will be the overseas citizen. Undivided India. India as a defined in Government of India Act 1935 is known as the undivided India. Now ordinary resident is a resident in India throughout the period of 12th month immediately before making an application, and residing in India during the 8 year immediately preceding and said period 12 month for a period of not less than 6 years. So that this will be the ordinary citizen if residing in India throughout the period of 12 months immediately before making an application, and residing to the 8 years immediately preceding said period of 12 months for a period of not less than 6 years. So 6 years is required to be resident of India. It's minimum criteria. Now it's changed little bit. Termination of citizenship. So renunciation of citizenship is any citizen full age and capacity can renounce his citizenship. Declaration by the registration. Declaration of renunciation which withheld during any war, and such child can again become a citizen of India by declaration within 1 year after attaining full age. Termination. Central government may by order deprive any citizen of Indian citizenship. Registration or certificate of naturalization by obtain the fraud. Citizen has shown himself by act or speech to be disloyal or disaffected towards Constitution of India. Unlawfully traded or engaged in any business to assist an enemy during war. Citizen is sentenced for 2 years in any country within 5 years of registration or naturalization. Citizen stay out of India for a continuous period of 7 years without any education or official purpose. So this is the deprivation of citizenship. If he is unlawfully traded in any kind of business, or if he sentenced for 2 years, or citizen stay out of India for a continuous period of 7 years, or registration or certificate naturalization is obtained by the mean of fraud. This is the renunciation of the citizenship of India. Fundamental rights. Fundamental rights of part 3rd. So part 3rd initially there was a 7 articles. Okay. Now 6 article and article 31 right to property has been removed from that, and 44 Amendment Act 1978 was there, and 300A. Article 300A and part 12. Okay, that was the Right to Property Act. Article 12. Now I am discussing about the fundamental rights. The fundamental rights are Article 12 to 35. Okay, first is definition of a state. Second is law inconsistent with or derogation of fundamental rights. Article 14 to 18 is right to equality. Article 19 to 22 right to freedom. Article 23 to 24 right against exploitation. Article 25 to 28 right to freedom of religion. Article 29 to 30 cultural and educational right. Article 32 right to constitutional remedy. Article 33 power of parliament to modify the right in part 3rd. Article 34 restriction on right during martial law. Article 35 legislation to give effect the provision of part 3rd. So these are some articles in the fundamental right which are important. Now characteristic of fundamental right. Fundamental rights are not absolute rights. They are qualified in nature. So they are qualified in nature. Fundamental rights are not permanent. No, it's not permanent. It's not absolute. And fundamental rights are justiciable. Justiciable and guaranteed by Supreme Court guarantee these act. And people can move to the court in case of violation. State can impose restriction as per the court standard, and they can be amended by constitutional amendment. An aggrieved person can approach the Supreme Court directly, and no need to appeal to the subordinate court also. So these was the quality of fundamental right. Now Article 12. Article 12 talks about the state. So government and Parliament of India, government and legislature of each state, all local and other authorities, all local other authorities under control of Government of India. These are known as the state, definition of the state. Now Article 13. Article 13 is a law inconsistent with the fundamental rights, like law inconsistent with the provision of Part 3 are deemed to be a void. Any law made by state which takes away or abridges the right under the Part 3 are void. So ordinance, an authorized order, a written direction of any court, bylaws, regulation made by local authority, corporation rules, regulations, a rule or directive made and maintained by authority, notification and custom law by establishment by or based on custom rather than common law. So these are the law included in Article 13, and if these laws are inconsistent with the fundamental rights, then this will be abolished. Okay. Now Article 14 to 18. These are the right to equality. Right to equality means equality before law. Article 14 talks about the equality before law. So state shall not deny to any person equality before law. State shall not deny to any person equal protection of law. Article 15. Article 15 talks about prohibition of discrimination. So states shall not discriminate against any citizen on ground of religion, race, caste, sex, place of birth. No citizen shall on ground only religion, race, caste, sex, place of birth is restricted. To access shop, public restaurant, hotels and place of public entertainment. To use of well, tank, bathing roads, and special case state is not prohibit from making and a special provision for advancement of socially and economically backward classes, special provision for the women and children also. Now Article 17 16 equality of opportunity. No citizen shall on ground only religion, race, sex, caste, place of birth is discriminate for employment. All citizens must have equal opportunity on employment, and state not prohibit from making special provision for reservation or promotion of backward classes, and state cannot impose it restriction on religion institutional regarding election of their official from same religion. Right. Now Article 17 talks about abolition of untouchability, practice of untouchability from forbidden, and untouchability is an offensive punishable law according to the law. Article 18 abolition of titles. So states shall not confer any titles and except military and academics. Citizen of India shall not accept any title, and foreign national holding office of profit under Indian government cannot accept any present and emolument and office of any kind of form under any foreign state without the consent of president, and foreign national holding office of profit under Indian government can accept foreign titles only after the consent of president. Alright. So these are some kind of articles given here. Now Article 19 to 22. So it is the right to freedom. Right to freedom. Article 19. All citizens have the right to freedom to speech. First, A. B. Assembling the peacefully. C. For association and union. D. Move freely throughout the territory of India. E. Reside and settle in any part of territory of India. And G. Practice any profession or carry any occupation. Article 19 D and E can be restricted for the protection of scheduled tribes. So D is what? Move freely in any area, and E is for reside and settle. So that can be protected, restricted in the protection of scheduled tribes. Right under Article 19G doesn't prevent state from making any law. Okay, it doesn't prevent any law to making any law. And to demand the profession, technical qualification of practice, they can demand to control the trade business. So state can control all of the trade and businesses. Article 20 protection in respect of conviction for a offence. So no person shall be convicted of any offence except for the violation of law.